Welcome viewers. The former president seems to think the justices are going to help him. They keep showing him that they won't. In this video we will break it all down for you, but before we continue please take a minute of you pressers time to hit the subscribe button below and turn on the notification bell to get the latest update from us. Earlier this month, former President Donald Trump asked the Supreme Court to intervene on his behalf in the litigation surrounding the federal probe into classified documents that were stored at Mar-a-Lago after he left office. His lawyers claimed that any limit on the comprehensive and transparent review of materials seized in the extraordinary raid of a president's home erodes public confidence in our system of justice. The Supreme Court apparently disagreed. Last week, only a day after the last filing deadlines had passed, the justices rejected Trump's plea out of hand with no recorded dissents. It's hard to read too much into the justices' decision, since it came without explanation like most similar orders. And yet, within 48 hours of the High Court's ruling, the Justice Department appealed the entirety of Judge Aileen Cannon's order imposing a special master on the investigation to the 11th Circuit Court of Appeals. Justice Department lawyers appear to have recognized what Trump and his legal team seem to have missed. The Supreme Court almost never rules in his favor in personal disputes and only occasionally sided with him on policy matters when he was president. Though the court's conservative wing is now firmly in control of its docket and rulings, it has only rarely handed significant victories to Trump. And yet the former president and his legal team never seem to tailor their expectations accordingly. The latest defeat came last week as part of Trump's effort to undermine the investigation into classified documents stored at Mar-a-Lago after he left the White House last year. Trump and his lawyers convinced Cannon, whom he had appointed to the bench in 2020, to block the Justice Department from using any of the seized evidence and appoint a special master to oversee the privilege claims. The ruling was widely criticized for, among other things, appearing to favor a former president's claim of executive privilege against the executive branch itself. Among Cannon's many critics was the 11th Circuit Court of Appeals. The Justice Department had appealed part of Cannon's order that blocked investigators from reviewing the classified documents it had seized during the Mar-a-Lago search. Prosecutors argued that their review was necessary not only for the criminal investigation, but also for the review of what classified materials were out of the government's control and the possible damage they could have done. The three-judge panel, which included two judges appointed by Trump, ruled in favor of the Justice Department. Trump's misunderstanding isn't completely baseless. In recent years, and especially after Trump took office, the Supreme Court has handed more than a few victories to conservatives and Republicans. Federal courts can no longer hear partisan gerrymandering lawsuits. The Second Amendment generally protects a right to carry firearms in public. Federal agencies have a harder time issuing regulations to address climate change. The Occupational Safety and Health Administration can't mandate vaccines or masks for most workplaces in America during a pandemic. States can pass restrictive voting laws without fearing challenges under the Voting Rights Act. Roe v. Wade is no longer the law of the land. But those victories have only rarely extended to Trump himself when they did not directly overlap with the GOP's goals or with movement conservatism's agenda. Trump and many of his allies may see these things as indistinguishable, of course. But most of the Supreme Court justices, whose conservative members come from an intellectual and philosophical tradition that predates Trumpism, apparently do not. The clearest example came in 2020 when Trump sought to stop two parallel investigations. In Trump v. Vance, the then president had hoped to quash a grand jury subpoena as part of a criminal inquiry into his businesses by Cyrus Vance Jr., Manhattan's district attorney at the time. In Trump v. Mazars, Trump also hoped to block a congressional subpoena into his financial records that a committee said it needed for a variety of legislative and oversight purposes. The two cases reached the Supreme Court at the same time and were heard on the same day. Please, what is your take on this, and remember to subscribe as well. Thanks for